everybody. Oh my God, I'm sorry I'm fashionably late. I don't know how that happened. Actually, I'm trying to get my phone to charge up a little before I did this. Hi Eve, Chris, Breaks. How's everybody doing this week? Chris's girlfriend is not here yet, I see. Okay, if anybody wants to come up on panel, they are welcome. Eve, you're more than welcome. I hope everybody's had a good week so far. I hope you guys can hear me. Can you hear me? Nobody's saying anything. Let me know. Okay, thanks, Rex. Okay, we're going to go over these cases first, and then I'm going to talk about Marshella Chidester, who down in Monroe, Michigan, ran her truck into the Swan Boat Club where they were holding a children's birthday party, and she killed 2 children, 4 and 8, and injured 13. It's really really tragic, really tragic case. Everybody's very deeply affected. I mean, gee, that's a lot of fatality. Yeah, did you see the video that I posted, Rakes? She is flying, and we'll get to why that might be when I go through her. We're going to go through her arraignment, some statements from the different businesses involved, and then the lawsuit that the mother has filed against the tavern and Marshella. Okay, so oh my goodness, trying to go off 2 phones here. All right, so our first case here is, I couldn't believe it when I pulled this up because it is uncannily like the Swan Boat Club case that we're going to be talking about. This also includes epilepsy and a car accident before the incident. It's just, hi, Agatha Misty. Hey, you caught us. Glad to see you. First time. Oh, I was going to, let me see if I can do it. I was going to post the, no, it won't let me. No, I was going to post the GoFundMe for the family. Yeah, it's pretty tragic. It's been in the news here, Eve. It happened Saturday, but she was arraigned today, so there's a lot more on it. Okay, so let's get into this case, and this is just, I can't believe this is just, I don't know, struck me as crazy that we would have this as our first case today. Okay, unscheduled delivery. Weetabix truck runs into store. This is Upper Teen, England, 1997, Mansfield v. Weetabix. That's some kind of cereal, I believe, or cracker. Terrence Tarleton was driving a 38-ton Weetabix truck when he started suffering the effects of a disease that he did not know he had. The disease, malignant insulinoma, how is that different from diabetes? I don't know. Prevented sugar from reaching his brain and causing him to drive like he was drunk. He did not understand that this was happening. As a consequence of his condition, Agatha Misty cereal, thank you. Are you over there and across the pond? As a consequence of his condition, he drove too fast, misjudged a curve, and sent his truck into a shop owned by Mr. and Mrs. Mansfield, who presumably had not ordered a shipment of Weetabix. In the hours before the final accident, he was seen driving erratically multiple times. The first time he was seen swerving. The second time he hit the vehicle ahead of him. He stopped and filled out an accident report with a policeman who noticed he was acting strangely. Finally, his truck was seen momentarily mounting a curb just before the crash. The Mansfields sued Weetabix for negligence, resulting in damage to their store. At the trial, there was evidence that Tarleton was usually a very careful, sensible, and conscientious driver who would not have continued to drive if he had been aware that his ability was impaired. An expert witness testified that one of the effects of the illness was that the sick person does not even realize that they can't think clearly. Do the Mansfields win? Ooh, Australia. I'll get there someday. Okay, so Tarleton is the driver. The Mansfields own the store. And they are suing Weetabix, the company, for negligence. So what do you think? And actually it says, consider, would it be different if Tarleton had an epileptic seizure while driving? And that's what our case that we're discussing after this, that's what she's claiming. I can't believe how I'm just floored about this case. Okay, so what does everybody think? Do the Mansfields win? Does Weetabix owe a duty? Do they owe a duty? Not to the Mansfields, but to the public? They're responsible for their employees, right? I think so. I think they win. If he had an epileptic seizure while driving, I would say no, they don't win. What do you think, Eve? Are you going to come up on panel tonight, Eve? Just leave me up here all alone? Okay. Yes. Chris? Where did Chris go? I think yes. And you know what? We're all wrong. How is that possible? Okay. No problem, Chris. Holy mackerel. No breach of duty, just bad luck. There was no way for the driver to know he was sick. This went to the Court of Appeals. The Mansfields won the first trial, but lost on appeal. It's not negligent to drive with an unknown medical condition. The court said that Tarleton was not able to assess the seriousness of his own illness. The court wrote that a reasonable person in Tarleton's condition would be a reasonably competent driver, unaware that he is suffering from a condition that impairs his ability to drive. The court treated the case like a situation in which a driver has had their first epileptic seizure. Okay, guys, pay attention to all this. While driving. If you have a seizure while driving, you may injure people. However, as long as you were obeying the law just before the seizure, you would not be guilty of negligent driving. On the other hand, a known epileptic would be liable if they had a seizure while driving and injured someone because they knew about their condition. Okay, file that away until we get to the end and get to discussing our case. Oh, Eve, sorry. Welcome.
Yeah, hi honey, how you doing?
Okay, how are you?
I'm okay. Got a little bit of a sick stomach, but I'm okay.
Oh, that's horrible.
Yeah, I know. I hate when I get upset stomach.
Yeah, I have a problem with that too. Weetabix may have had to prove they had health checks on their drivers. I would think so, Agatha Misty, because, here you have to have a DOT physical. They're pretty strict on who can drive, especially a 38-ton truck. So I don't know. And this was 1997. I don't know the laws in England, or if there's anyone here that does. Okay, case 72. 4-year-old escapes school. Ammanford, England, 1955. Uh-oh. Lewis v. Oh my God. Carmarthenshire County Council. Smart people design systems so that when mistakes happen, the system keeps the error from becoming a catastrophe. When a teacher at a local nursery school was called away to attend to an injured child, she left a 4-year-old boy alone for 10 minutes. In that time, the child went outside into the play yard, opened and unlocked a gate, and walked down a lane into a busy highway. A truck driver, Lewis, swerved to avoid the child, struck a telephone pole, and tragically died. Lewis's widow sued the Carmarthenshire County Council, which was responsible for the school, for negligence. Does Lewis win?
No.
You don't think so? But the council owned the school. The school teacher left the 4-year-old alone, and he got out. You say no? Rake says no. Really? I'm going to say, yeah. Oh, Lewis's widow. Wait a minute. Swerve to avoid the child. Consider, is it reasonable to require teachers to know the whereabouts of every child at all times? Absolutely. So, if she hadn't have lost track of the child, which was her duty, he wouldn't have been out there and the truck driver wouldn't have had to swerve and get killed. I'm flummoxed. Okay, you guys, Rake says no. Agatha Misty says she hopes so. And
Well, I hope so too, but you know how these cases are.
I know how they are. Especially a 4-year-old. I know.
Yeah,
Okay.
we try to do the logic on them, but sometimes it don't work that way.
Well, yes. Now, who has the duty to who here? Let's see. The school has a duty to watch the kid, right?
Yes, I agree with that, but it's hard to watch every little kid you got if she's by herself as a school teacher.
Sounds like she only had 2. She's called away to attend to an injured child and left a 4-year-old boy alone. 10 minutes is a long time to leave a 4-year-old, isn't it?
Yeah, it is.
But
So
he really traveled, didn't he? Went out to the play yard, opened an unlocked gate, and walked on a busy lane. Okay, but the truck driver's widow is the one suing. Okay, so I'm thinking it's a nursery school, so not like kindergarten. Yep, okay. That's a good point too. Yes, and the county council. Okay. I don't know. I'm lost. Okay, Rake says no. Agatha Misty says yes. And what do you say? You said
no, that's what I said. So I'm gonna stick with
no.
it, but
No,
I'm probably
you
wrong
don't
on
think
this
so?
now.
She does win. House of Lords. Lewis wins. The school breached its duty to keep children from leaving. Wandering children are foreseeable. The court ruled that the accident was not caused by the teacher, but by the school's negligence. Holy crap. A school
Okay.
the teacher wasn't negligent. A school can foresee that unsupervised 4-year-olds may try to wander off. Yeah, I'd probably wander off. If the school has an unlocked gate and is next to a highway, the child will likely become a traffic hazard. Does it say unlocked gate? It does. Open an unlocked gate. Why the hell would they keep it unlocked?
That's what I get ready to ask you. Why would there be an unlocked gate for the kids there?
Okay, so that's why I'm thinking the death of. Oh, just a minute. Wait till I finish this. The death of the driver instead of the child. Welcome, Zoots and Boots. The death of the driver instead of the child was unexpected. Well, the death of the child is pretty unexpected too. But that did not change the fact that death was a likely outcome of the negligence. Therefore, a school that does not take reasonable precautions, such as a childproof gate, yeah, I agree, to keep unsupervised 4-year-olds from escaping is acting negligently. I didn't even catch the part about the unlocked gate. Yeah, that's crazy. Hey, girl, what's up? I like these ethical topic discussions. To me, the law implies a driver is responsible for driving safely. Yes, absolutely. The school has responsibility, but not culpability. It's interesting that they didn't find the teacher. I'll bet you the teacher lost her job there. Although, no, because that gate should have been locked. Okay, case 73. Now here's a good one. Woman slips on pizza slice. Oh, heavens. I'd hate to think a pizza slice got wasted. Okay. Denver, Colorado, 1972. Jasco v. F.W. Woolworth and Company. More than 40 years ago, eating pizza and hoagies. Wait a minute, rakes. I know I'm not supposed to be looking at chat. We just did a daycare case here in town. It was all on video. Tot got out, went into the road. Lucky a man sees the child. All charges were dropped against the worker. That's kind of scary. I wonder if there'd be a civil suit. Okay. More than 40 years ago, eating pizza and hoagies at Woolworth's department store was a thing. As Edna Jasko was leaving Woolworth's, she slipped on a piece of pizza by the pizza and hoagie counter. You're okay, Zoot. And injured herself. She slipped on a piece of pizza by the hoagie counter. Okay. There was no seating, so customers stood and ate their pizza, which was served on wax paper. That's kind of hard to eat standing up, juggling your food, I think. Because Woolworths sold between 500 and 1,000 slices each day, dropped pizza was common. The store understood the danger and had employees constantly inspect and clean the smooth terrazzo floor, which was slippery when covered in pizza. It would be extra slippery when it got wet. That's odd. In Jasko's case, the store had not been notified of this particular spill, so it did not have any time to clean it up. It may have happened seconds or minutes before Jasko arrived. Jasko sued Woolworths for her injuries. 2 sets of judges dismissed the case because they thought that the store should be given a reasonable amount of time to clean up spills. Jasko appealed to the Supreme Court of Colorado, asking that the case be brought before a jury. Does Jasko win her appeal and get to bring her case before a jury? Consider, does the store have a duty to keep the floor clean even if the pizza falls 5 seconds before a person slips? Is that like that 5-second rule?
Oh my.
Um,
I'm not sure about this either. Boy, these are kind of on the hard side tonight.
I'll try to slip an easy one in here. These are, but they're kind of building on what we learned from previous cases. So, okay. She slipped on a pizza. She sues. They thought the store would be given a reasonable amount of time to clean up spills. How do we know they didn't have a reasonable amount of time, though?
It takes a few minutes to clean up a pizza and spills and stuff. I mean, I used to work in a pizza place, so.
Oh, really?
Yeah.
I'm thinking nobody told the store. I think get rid of that terrazzo floor, because if they had rubber mats up there where people are standing, it wouldn't happen. That's a kind of a slippery kind of floor to have, but that's neither here nor there, I'm assuming. Does Jessica win her appeal and get to bring her case before the jury?
I don't know. I'm gonna say yes.
Okay. What you say, Rex? Do Supreme Court of Colorado. Okay. Yes. Rex says yes. Jessica wins, gets to bring her case before a jury. The accident was foreseeable, and the cost of avoiding the accident was small. Normally, a business has to be given a reasonable amount of time to discover and fix hazards. This is because it's assumed that hazards are not common. However, because Woolworths was cleaning up spills constantly, the court thought that notice was not necessary. Woolworths had a duty to eliminate the risk. The fact that it was a small area meant that the cost of avoiding the hazard altogether, listen to this, by putting down a rug or rubber mat, for example, who suggested a rubber mat, was small. Jasko's injury was foreseeable. It was Woolworth's duty to make the floor safe. Huh. Okay. Louisiana. Here we go. This is a long one. I don't think this is going to be an easy one either, Eve.
Oh my.
Case 74. Louisiana working to keep poison out of our gumbo. I don't eat gumbo. I don't like all the peppers and stuff. Hot stuff. New Orleans, Louisiana, 1985. Louisiana v. MV Test Bank. The container ship MV Test Bank had passed New Orleans and was slowly steaming towards the Gulf of Mexico on a channel of the Mississippi when it ran into it's got to be merchant vessel, I'm thinking MV C. Daniel. The collision released a cloud of poisonous gas and caused 12 tons of the chemical PCP to fall into the water. PCP is toxic to humans and marine life. People within a 10-mile radius were evacuated. The channel was closed for 19 days for cleanup. Health officials temporarily stopped all shrimping and fishing for 400 square miles. The cost of the cleanup and channel closure were enormous. Many groups joined in suing Test Bank for their economic losses. The long list included the state of Louisiana, I'm sure there was a lot, marinas, bait shops, restaurants, railroads, and commercial fishermen, which included crabbers, oystermen, and shrimpers. Even before the case went to a jury to determine negligence, Test Bank asked the court to throw out the case. Test Bank argued that unless claimants' physical property was damaged or they suffered physical injuries, they could not sue. Does Louisiana win and get a trial? Wait a minute. Okay, Louisiana is suing. The state of Louisiana is suing Test Bank. Hey, Misha, girlfriend. Glad you could get here. Do the marinas, bait shops, restaurants, and railroads win and get a trial? Do the commercial fishermen win and get a trial? Holy. Yes. Well, and here we are, environmental damage. I consider, how would the court's decision affect insurance costs for companies that ship chemicals? I don't care about that. Do commercial fishermen own the fish they're going to catch the way a farmer owns a pig that escapes his pen? No. That's a good question. This is a hard one, Eve.
I know. I'm sitting here trying to think what so
Well, I think Louisiana ought to win because obviously it's damaged. Obviously, it's damaged the ecosystem, right?
yeah.
The marinas, bait shops, restaurant, and railroads. I think they should win because they had a loss of business. Do the commercial fishermen win? How do you, like it
I'm gonna say
says,
no.
yeah, me too. Do commercial fishermen own the fish they're going to catch? They could just go somewhere else, couldn't they? Or, I mean, how do you
Yeah.
base what they get because you don't know what they would have caught anyway? 19 days. Yeah, I wouldn't want to be eating any shrimp from there for a while. It's 1985. I suppose it's safe now. Okay, ready? Everybody ready? Whoa. The United States Court of Appeals for the Fifth Circuit. Commercial fishermen win.
Oh my.
The one person we said no.
See, I told you can't ever tell. I think sometimes we just use too much logic on this phrase.
Commercial fishermen win, the rest loses. Only the commercial fishermen suffered damage to their property, fish, crabs, and shrimp, so only they get a trial. This is interesting. The fact that the accident happened on sea and not on land helped the commercial fishermen because it meant that maritime law would not apply. Maritime law treats fish, oysters, maritime law would apply. Did I say that? Maritime law treats fish, oysters, shrimp, etc. as the property of commercial fishermen, even though the animals may come and go as they please. Well, now we're into maritime law. I did not know that. That's interesting. Test Bank breached its duty to not damage the property of commercial fishermen when its chemicals made their property inedible. Had the chemical spill happened on land, then flowed into the channel, maritime law would not apply and the fish would be considered free and not the property of the commercial fishermen. Now that's interesting.
Hey,
Huh.
like I said, you're never too old to learn things.
I know. That's why I like the law. You never know. The court feared that this lawsuit could hurt commerce. Shipping companies need to buy insurance, but if the potential costs of a chemical spill are astronomical, then no insurance company will sell insurance. Without insurance, no company will ship chemicals, and without chemicals, many factories would be forced to close. Well, so they're kind of taking how it would affect the public in general. In general, courts don't want lots of people suing for an uncertain amount of money, which was the case here. So the
Yeah.
U.S. Court of Appeals deferred to tradition, which capped liability for shipping accidents by limiting claims to those with damaged property or injuries. This was a chemical spill. Oil spills, however, are treated differently. The oil spill from the Exxon Valdez tanker prompted Congress to pass the Oil Pollution Act of 1990. This law set aside a fund paid for by an oil tax to pay for cleanup and economic damages. Payments from the fund are capped at $1 billion per spill. That's interesting. Ships ahoy. Yeah, I thought the state should help get some money. Maybe that just falls under disaster, the U.S. government or something. Do you want to come on panel? Zoots and boots? You're more than welcome. The more the merrier up here. Okay. Slow service, customer ignored to death. Uh-oh. New York, New York. 1935. Zelenko v.
Oh
Gimbel
my.
Brothers. What? Year you were born?
Yeah, that was a long time ago.
Yep. Mary Zelenko got sick in the Gimbel Brothers department store. I'm gonna see if I can drop the link for. Yes. You're welcome to come up, anybody. The staff took her to the store's infirmary, where she remained for 6 hours without receiving medical care. Oh, no problem. We'll catch you next time. During that time, no ambulance was called, and her condition continued to worsen until she died. Oh my God. Zelenko's husband sued Gimbel for negligent care that caused his wife's death. Before the trial began, Gimbel asked the court to throw out the suit because it had no legal duty to rescue Zelenko. Does Zelenko win? Consider, do we have a duty to rescue a person who is in danger? The fact that they had an infirmary on site, I would think they're responsible. What do you guys think?
I agree with you. Because, like you said, they had it, they had on site and everything, and so.
Nietzsche said that's negligent. I think so too. Well, yes. They're responsible. I think they have a duty to their employee. Why didn't they just let her lay there sick for 6 hours? Yeah, I'd say the fact that they had an infirmary meant that they did have a duty to treat someone who was sick. Okay, ready? Yes, Zelenko wins. We're right for once. Okay, Supreme Court, New York, special term. Zelenko wins. Upon beginning the rescue, Gimbel had a duty to do it to the standard of a reasonable person. Yeah, me too, Misha. Unfortunately, not everyone thinks that way. The moment Gimbel's staff decided to help Zelenko, they accepted the duty to rescue her to the standard of a reasonable person. Staff could not begin the rescue and then say that they had no duty to continue the rescue they began. In the United States, you have no legal duty to rescue, even if the rescue would take almost no effort at all. There are exceptions, of course, such as if your negligence created the danger, but the general principle holds even today. This principle, however, is not recognized in most other countries where the law requires some effort to help, even if it's only the equivalent of dialing 911. Because there is no duty to rescue, staff could have left Zelenko on the store floor and done nothing at all. No doubt a good Samaritan would have noticed her and called an ambulance. That's a good point. But Zelenko got the worst of both worlds. Staff took her from a place where she could be found and helped by a good Samaritan and moved her to a remote infirmary. Then they failed to summon or provide medical help. Yes, duty of care. That's the theme through all these. I don't like that you don't have. I'm surprised to read other countries have laws where you are required to help. I wish we did. I know we absolutely. Yes. Did you say New York City? Yeah, New York, New York. Wasn't that one? Or was that the one before it? Yeah, this was New York, New York, Misha. Okay. Oh my God. Here we got another ship one. Going to learn a lot about maritime law here, I think. Skipper sees sheep slip off sheep shipper's ship. Give me a round of applause for saying that.
Let's hear you say that again.
I'll try. Skipper sees sheep slip off sheep shipper's ship. Did it. Okay. The North Sea. 1874. This was before you were born, Eve. It wasn't. Gorse v. Scott. Oh, there's a little sheep on here. We are all shipborne sheep struggling to keep our footing in a gale. Goris shipped his sheep. I didn't get all the way
Lord.
through this yet. From Germany to England on Scott's steamship. The boat did not have proper pens or footholds, so when a gale came up, it washed a large number of sheep overboard. That's horrible. There was no agreement between the parties as to how the sheep were to be handled, but there was a law, the Animals Order of 1871, that required animals to be kept in pens that have proper footholds. These precautions reduced the likelihood of disease, which could then spread to the farm animals in England. Had the sheep been penned, they would have survived the storm. Goris sued Scott for the negligent boat facilities. I think that's a tornado siren going. Let's hope not. Goris sued Scott for the negligent boat facilities, which led to the loss of his sheep. Does Goris win? Consider, should the purpose of a law be more or less important than the actions required by law? So they're saying that the law was meant to reduce disease. So should we apply that to a ship where the purpose of the law doesn't apply?
I'm gonna say no.
Thank you, Misha. You don't think Goris wins?
No.
I think
I
the
could be.
sheep. Nothing's going to
I'm
bring those
probably
poor,
wrong.
those
I'm
poor
probably wrong.
sheep back. Oh my
I'm not
god!
doing very good tonight.
I don't like things where animals get hurt.
I know that, but yeah, I mean,
I
I mean,
say, I don't know. What does the maritime law say?
honey, I don't know. I mean,
This
it
was
seems like
18.
if we use too much logic, it seems like we get them all wrong. I don't know.
Should the purpose of law be more? Okay. Does Goris win? Negligent boat facilities. This was Scott's steamship. Okay, here's a point. Goris obviously knew, right? That the sheep didn't have proper pens and footholds. So did he take that on himself?
Probably so.
No. Okay, what did you say, Eve?
I
You
said
said
no.
no. You're right. Goris loses. There was no duty to protect the sheep from being washed overboard. Courts have to consider the reasons for rules. Okay. The rule about pens was established to stop the spread of disease. So while Scott was in violation of the rule, the death of the sheep by drowning was not what the law was intended to prevent. Ah, just because a rule is violated and loss happens does not mean that negligence happened. In this case, the rule was not enacted to protect animals aboard the boat, but to protect animals in England. If Goris had a contract with Scott on how the sheep were to be transported, then Goris could have specified that the sheep be penned. Without that agreement, Scott is not liable for the loss of the sheep. Those poor sheep.
Well,
Quarantine.
stuff like that happens, honey. I mean,
I know. Quarantine and maritime security are really serious. Yes, I think so. In the interest of human safety than animals. Um, there's some kind of horse thing going around right now. It has an odd name. I can't think of what it is. Yeah, I don't know. I'm glad I don't have any animals outside.
I don't have no animals no more. I used to have a couple dogs, but I don't have any more now.
Yeah, they're so well with dogs. You have to let them go outside. So you got to worry about heartworm and
Yeah,
some of
gotta
that
let 'em.
other stuff. Yeah, seems like there's a lot dogs can catch. Okay, woman sues doctor for not warning of risks. London, England, 2004. Now that wasn't that long ago. Chester v. Afshar. Pain undermines good decisions because it distracts us, and it's hard to think clearly while distracted. Carol Chester had had back pain for 6 years before being referred to Dr. Barry Afshar. Afshar suggested surgery, however, he did not warn her that even if the surgery went well, it still carried a 2% risk of either no improvement or worsening the condition. Chester had the surgery. The surgery was performed without negligence, but she was in the 2% group and her condition got worse. She sued Afshar for failing to warn her about the risks. At the trial, Chester said that she would have taken more time to make the decision, but could not say whether she would have changed her mind about having the operation. Afshar argued that she would have likely consented to the operation anyway, and that the failure to warn did not actually cause the injury. Besides, he was not negligent in the performance of the injury itself. Does Chester win?
Well, I don't know, but he did tell that some things that wouldn't work, maybe.
I don't. Does a doctor have a duty to provide patients with information about all possible side effects?
Not nowadays.
I don't know. They say the only sure outcome of back surgery is more back surgery, which is why I never had back surgery. I think anybody that's had back surgery will agree with me. Hi, Margaret Gran. I would agree. What if that's a good point, Zoots and Boots. What if she had a reaction to the anesthesia? That would be
Yeah, that
interesting.
happens.
He didn't warn her about that either.
Nope.
Okay, Rakes thinks that Chester wins. Holy moly. I think he did have a duty to warn her. I don't know. Anytime I get prescribed a new medicine, I come right home and quick read all the side effects and everything.
That's a
Hi,
hard one, too.
Winston. Hey, hon, glad to see you. What?
I said, that's a hard one, too.
Um,
I'm on the fence with this, and I'm trying to think.
Everybody agrees with me about back surgery. Yeah. Does a doctor have a duty to provide patient? I think
I'm gonna say yes,
yes.
because they do, but they don't always tell you.
No, but I do think they do. Well, yeah, you're in that situation.
Yeah, that hits
Okay.
home.
Chester wins. Dr. Afshar had a duty to warn of risks. In a 3-2 decision, the House of Lords sided with Chester. It ruled that her right to make a fully informed decision was violated by Afshar, who breached his duty to give her the information she needed. The court wrote, "The function of the law is to protect the patient's right to choose." It did not matter whether Chester would have decided to have the surgery, because as a result of the surgeon's failure to warn the patient,
Well,
she cannot be said to have given informed consent to the surgery in the full legal sense. The court discussed the issue of whether the failure to warn actually caused the injury. In the end, it decided that the actual injury would not have occurred when it did if Afshar had given Chester the warning. If he had, Chester would have taken more time to decide. The risk that a doctor could escape consequences after failing in their duty to warn was, from a public policy perspective, unacceptable.
it's just like my knee doctor done my knee. He didn't give me all the side effects and stuff. What could happen? So I mean, still there, Lisa?
I'm
Oh,
still
Lisa.
here. I'm coughing.
Oh, okay, honey.
I did drink go down the wrong pipe.
Oh no.
I know. Just a minute. Okay, I'm back.
Okay,
I'm
honey.
squeaky but back. Man accidentally ignites its Halloween costume. I think they have to make them inflammable now. That's okay. I'm glad you're here. Mr. and Mrs. Ferlito went to a Halloween party dressed as a little Bo Peep and her sheep. Sheep seems to be a theme tonight. They'd created the sheep costume with cotton batting made by Johnson & Johnson. I know I'm talking funny. Well, looking at the other guests' costumes, Mr. Ferlito absentmindedly lit a cigarette and touched the flame to his cotton costume. He was engulfed with flames in a matter of seconds and suffered severe burns on a third of his body. The Ferlitos sued Johnson & Johnson for negligently failing to include an inflammable warning on the package. When questioned at the trial, however, they admitted that they knew the cotton batting was flammable, but said they had no idea that it burned that fast. Mr. Ferlito also said that he ignored the warnings on his cigarette packages every day. That's a good point. The Ferlitos showed that many teachers used the batting for classroom projects, so it should have been obvious to Johnson & Johnson that the product would be used for many things besides cleaning, applying medications, and infant care. Do the Ferlitos win? I don't think that children
I was
making
gonna say,
classroom projects are going to be smoking.
I don't know. I'm gonna say no.
Is a warning necessary for someone who already knows the danger? Yeah, I know. Empathy with patients is important, providing, yes, the back operation. I agree. Should have been warned. But yet, when they prescribe medicines to you, they don't go through all the side effects. Ordinarily, not all the side effects. You ever notice, like, something that's for pain? One of the side effects is like a headache and muscle aches and pains. And I'm like, they always can. One of the side effects is always whatever you're taking it for. The funniest, Misha, is when I used to deliver to Pace Warehouse, and it was like a Costco or Sam's Club is today, only it was before they existed. And I delivered a case of sea sponges, and they had the warning on them, not for contraceptive use. Like, who's going to use those for contraception? Yeah, rebound headaches are bad. Okay. So, do the Ferlitos win? I say, I say no. What do
Me
you
too.
say? No?
Yeah, I done said no.
Yes, we're right. This went to the United States Court of Appeals. The Ferlitos lose. Mr. Ferlito assumed the risk of burns because he knew that cotton is flammable. Chris, you weren't even here for it. A jury awarded the Ferlitos more than $600,000 in damages. But upon the United States Court of Appeals threw out the verdict. The court said that a warning from Johnson & Johnson would not have made any difference because the Ferlitos knew the costume was flammable. That's a good. That meant the failure to warn was not the cause of the injury. It was Mr. Ferlito's negligence.
Uh-oh, that's pretty girl.
Hey, squirrely girl! In short, Mr. Ferlito assumed the risk of his costume catching fire. Kind of odd that Chris would come in here at the same time as Squirrely Girl, isn't it? I mean, could have just been coincidence. I don't know. Johnson & Johnson could not have foreseen that an adult would cover himself with cotton and then deliberately expose himself to an open flame. The fact that the cotton batting is used for other purposes was not relevant to Mr. Ferlito's injuries. What do I got? Remember this? No way. No way. The lady that sued her gynecologist because her labor was painful? No way. There's what was
Okay.
circumstances. She didn't. Oh, I don't even want to think about that. Oh my goodness. No. Okay, maybe they made a costume out of it. Okay, let's go on to the next one. Two more, and then we get to our main course here. People are idiots. Man sues after being run over, robbed, and shot. Okay, nice. London, England, 1969. Baker v. Willoughby. Baker was crossing a lightly trafficked road at 7 a.m. Saturday morning. I wouldn't be out that early if it was me. He looked before crossing and saw a car, but did not see a second car driven by Willoughby that was speeding as it passed the first car. As Baker crossed the road, Willoughby's car appeared from behind the first and struck Baker, injuring his leg and ankle. Before the case came to trial, Baker, whose luck was not good, sounds like me, was the victim of a robbery. When the robbers did not get money, they shot Baker in his injured leg, which then had to be amputated. Baker sued for his medical costs, pain, and lost wages. He had to take a lower paying job because of the first injury before and after the shooting, as if the amputation had never happened. At the trial, Willoughby argued that Baker was also negligent, and that even if he owed for Baker's medical costs and lost wages before the shooting, he did not owe Baker for any costs that happened after the shooting. All money owed post-shooting was owed to Baker by the robbers, who were never caught, who took Baker's whole leg. Does Baker win? What impact might the original injury have had on the second injury? I say none. I say Baker loses.
I do too. I
Um,
mean, some of
well,
these things are really hard to answer. I mean,
does Willoughby owe a duty to Baker? Well, he does, right? I wonder why. Okay, here we're going. Willoughby couldn't see Baker because of the other car, and Baker couldn't see Willoughby because of the other car. They're both kind of negligent, because if you can't see, you don't go,
yeah,
right?
I agree with that part.
Okay, so the shooting and the leg amputation has nothing to do with this, as far as I'm concerned, because what does that have to do with this? Nothing. Okay. Greg says no. Misha says yes. Chris is busy flirting. Squirrel Carol says yes or no. Let's Baker win. I'm going to say does Baker win?
Remember when you both said we could know?
I'm going to say no. I know I'm going to be wrong. Ha! Split decision. I did say that. House of Lords. The amputation did not end the requirement to pay for costs that would have happened. The court reached its 75-25 split on fault by considering two factors: the accident's cause and who was to blame. Regarding the cause, Baker was negligent because he did not see both cars and did not wait for either to pass. Willoughby was negligent by speeding and not seeing Baker. Yet the court said that Willoughby was entirely to blame because his error hurt others, while Baker's error hurt only himself. The loss of Baker's leg did not let Willoughby off the hook for paying for all the costs of his negligence. The judge called the argument more ingenious than interactive. What? Wait a minute. The court thought it was possible that Baker's gunshot wound may have happened in part because Baker could not flee the robbery. What? It also thought that the injury Willoughby caused may have made the gunshot wound worse. I think the court needs a medical specialist to testify. All right, you guys, I can't look at chat anymore.
No, don't be looking at chat.
It was important that there was a connection between the first and second injuries. In another case, Javelin v. Associated Dairies, a worker was injured by negligence, then later became disabled by another completely unrelated illness. In that case, the court took into account the illness when deciding how much was owed. Okay, if you say so. Okay. Case 80. This is our last one. An unfortunate series of events leads to accident. Doesn't it always? New York. 1966. Hill v. Edmonds and Bragoli. New York. That feeling when you're driving on a dark road in a rainstorm and you suddenly see the silhouette of a truck parked directly in front of you. That's nice. On a stormy night, Bragoli left his delivery truck in the middle of the road without turning on his emergency or any other lights. Edmonds was driving his car too fast for the conditions and ran into Bragoli's truck. Gertrude Hill was in the car and injured in the crash. Hill sued Edmonds and Bragoli for her injuries. At the trial, Edmonds said it was not his fault, that there would have been no accident if Bragoli had not parked without lights. Bragoli said it was not his fault, that there would have been no accident if Edmonds had been driving carefully. Does Hill win against Edmonds, the driver of the car? Does Hill win against Bragoli, the owner of the parked truck? Can both Edmonds and Bragoli escape blame because no accident would have happened without the other? Oh, I hate these. Okay. Bragoli. I think she just wins against Bragoli. Yeah, Edmonds was driving too fast for conditions, but he wouldn't have hit the truck if it had had lights. Exactly, I think too. Okay, what do you say, Eve?
Yes.
Against the driver or the truck? I say the truck, the owner of the parked truck.
Well,
Bragoli.
look, yeah, I mean, like I said, we get logic and then we mess this case up.
Oh my God, Hill wins against both. Supreme Court of New York. When both parties are negligent, each can be held responsible for the entire result. That's interesting. The court thought that both Edmonds and Bragoli could be held responsible. It did not want to excuse one party or both from blame because each negligent act alone was not sufficient to cause the accident. The court ordered a new trial so a jury could decide how much each had to pay. Well, that's interesting. Okay, that's all the cases for today. Now we're going to talk about Chris. Okay, let me pull up here we go, photos. I don't know what that is. Okay. So here is this lady, Marshella Chidester. She was allegedly drinking, and if you saw the video on my community post, she was hauling her truck. She crashed it into the Swan Boat Club in Monroe, and there was a birthday party in there for a child, and she killed 2 children, 4 and 8 siblings. The 4-year-old was trapped under the truck and injured 13 others, including the 2 children's older brother and mother. So here, let's go through she was arraigned today. She got $1.5 million in bond. Leg seizures. Yeah, the leg seizures are in here. That's part of her. Okay, so I'm going to go over the transcript of her trial, and the judge let relatives talk. He let them give victim statements at a bond hearing, which was kind of unusual. And then we'll go over the lawsuit. That's the mother is suing the driver and the bar that she was at before she got in the car. So this is kind of like the Morgan Wallen trial, or like Riley Strain, how they went to the bar to see if they, had overserved him or whatever. Oh my goodness. You guys. Okay, so let's go through this transcript. The next probable cause conference will be April 30th at 9 a.m. Okay, here, Your Honor, the people are requesting 1.5 million bond at this point, along with conditions. It is based, at least in part, on the fact that, as the court has already indicated, the defendant is facing 2 life sentences that could run consecutive to other offenses that are involved in this matter. In addition to that, we believe that the likelihood of conviction is extremely high here. We have ample video evidence showing exactly what happened during this incident. This is her lawyer speaking, this is the prosecutor speaking. A very severe, this surprised me. Finally, Judge, the defendant suffers from a very severe substance abuse issue, corroborated by friends and family members, and she creates a very high risk to the public for all those reasons. Now, I did a background check on her, and she doesn't have any arrests or any tickets or anything. We believe that a $1.5 million bond is in order in this particular case, Your Honor. Bill Covis, on behalf of my client, Your Honor, and this is her lawyer speaking, I think the court has served in judiciary for many years and understands and appreciates that at an arraignment, the client has not been found guilty. We don't have any prejudgment penalties. What we do have here is somebody, when looking at bond and any favorable and unfavorable acts, the favorable facts are my client is 66 years of age. My client has no record whatsoever. In fact, she has never even received a traffic ticket of the 50 years she is driving. She's better than I am. In 60 years on this earth, she's never had any traffic involvement. She's never had any law enforcement involvement. I think that adds a little credibility to her side of the table. In addition, she's owned her residence, which is about 400 feet from where this took place, for 40 years. She's retired from a position and was living a peaceful life with her husband in retirement. What the fails to mention to the court prosecutor is that she has a history, and even the neighbors in the news media have said that she drives like a little old lady. That's not really a good thing, I don't think. When she drives, you got to drive around her. That is, in addition, my client has a history of having seizures. Okay, she has a history. And this history has lasted since last November. It started of epileptic type seizures in her legs. In fact, that's the day she was treated for it. It's not like her to drive drinking. If I may continue, with all due respect from everyone, a search warrant was executed at the bar that was allegedly where she was at. The bar showed that she had 1 glass of wine 4 hours prior to 3 o'clock, which is when the accident occurred. Between 11 and 12, and a bowl of chili that was confirmed with the search warrant of that receipt. Now, they did execute a search warrant. They closed the bar, and they did apparently confirm that she had 1 drink. However, this was between 11 and 12. The accident didn't occur until 3. So even if she only had 1 glass of wine, there's a lot of time in there for her to drink more. Okay. The doctor, no doctor told her not to drive. The doctor told her not to drive for a number of months, very few months, and then she could operate a vehicle about a month prior to this accident. Actually, he said the end of March. She was finally able to drive again because of the epilepsy, which, yeah, that's sad. Your Honor, because I
Good deal.
want excuse me. I'm not doing a trial today, but I want the court to know everything in setting in the box that this is not a monster. What happened is absolutely horrible. I have 2 children. It's absolutely horrible, but some things we don't have control over. If I have a heart attack at my age, I don't have control over it if I'm operating a vehicle and to hit somebody. So, Your Honor, the 1.5 million in the murder charge, I don't know where that's coming from. But they have to prove it, and respectfully, Your Honor, we would ask for a $100,000 cash bond or 10%. She can have the court can order home confinement. Police have never been called to a home. She doesn't even have a speeding ticket. He keeps mentioning that. If there's such a substance abuse at 66 years of age, so we're asking for home confinement along with $100,000 cash assurance. In addition, she can have an alcohol monitor, any violation whatsoever, bond revocation, but she gets medical treatment. In fact, they have all the prescriptions she's on at the jail, which are numerous, because of the paralysis she gets once in a while in her legs. And it's all documented, and I'll bring forward the medical records. So we're burning somebody at the stake by just craziness, just crazy words. Because there's been deaths, which is horrible, absolutely horrible. But we have to go back and say, how did it happen? If me, Bill Kovas, had a heart attack on the freeway and I had somebody changing a tire, I can't be liable in today's society. Yeah, but your ass wasn't drunk. Oh, somebody interjected. Let me repeat. They did a search warrant and it showed 1 glass of wine 4 hours prior. Thank you, Judge. Okay, so Judge, why do you keep not hit your brake or turn? Because sometimes you have a seizure or your legs freeze up. Your Honor, there's no indication whatsoever that in any of the evidence that we have uncovered in this case that the defendant suffered from a seizure at the time of this incident. In fact, quite the opposite. A very long investigation has occurred. There was a preliminary breath test done, which indicated that her blood alcohol level was significantly over the legal limit. What's more, it is based on, she indicated herself that she had some seizure issues and she was on some medication and that she wasn't supposed to be drinking, but admitted that she had been drinking that day. So she is a danger to this community. And that is illustrated no clearer than the 2 dead children that she is directly responsible for. A $1.5 million bond in this case is a gift, and that's what I'm asking the court to consider. How do you save the community from the rumors are that she drinks in her car and parking lot? Excuse me, rumors, hopefully they don't have rumors on any of the people here today in the state of Michigan. If you have a seizure, Your Honor, may I continue? Yes, she took my 2 grandbabies. I'm start the day. Oh, okay. Okay, they muted and then started talking again. If it's the safety of the public, there's no history whatsoever. Number 2 is she can be put on an alcohol tether. Number 3 is she can be put in her home. If she violates her home to go get her mail, she can be picked up and put in without bond. We'll stipulate to that. So you know the court see many, many people, thousands of people before the court and has seen criminal history. We don't even have a traffic ticket. She doesn't have a traffic ticket. Okay. But she was drunk. It's absolutely horrible, but we're not punishing somebody before they're convicted. Thank you. Any wish to address the court? Okay, so I believe this is the grandmother to the two children that were killed. And he lets witnesses give victim statements here, which is kind of unusual. Um, she chose to drink, and those were my grandbabies. Thank you, your name. She made that choice that she did to drink and drive, and she took my grandbabies from us. Let's see, understood your name for the record. Probably doesn't want to. Oh, ma'am, my name is Chasey Phillips, and I'm the grandmother of the two babies that were killed. Thank you. Some factors I've considered in setting bond. She has no criminal history, identified criminal history, no incidents of non appearance. Your Honor, one of the victims does want to speak to the court. May she? Could we start with your name, ma'am? My name is R.H. Brothers. I'm Mariah's sister. Mariah is the mother of the two children. What he had said about getting injections in her legs for something, knowing that with or without drinking, you're still putting people in harm's way because with muscles and everything, you can't control something. Why operate a vehicle when you know you're taking medicine that drinking will affect? If I was there, I see my daughter, my mother, my sister, my nephew from the opposite side of the family, my sister's three children. We were supposed to be planning a birthday party for Zane, which was the little 4-year-old boy. It was going to be his 5th birthday soon, not a funeral. Knowing you have medical conditions, you should never get behind a wheel, whether you're drinking or not. Taking medications, they tell you not to drink, but she still chose to drink. And she still chose to get into that vehicle. I will never look at the month of April the same ever again. My birthday was a few days prior. The babies were just at my house. My niece, with her flawless curly hair, loves to dance. My nephew, he always hated my truck because it was dirty. I cleaned my truck out just for him. He loved jujitsu. He loved cracking jokes. Eminem was his idol. They walked into that birthday party having a fun time. They were sitting at that table eating, and this woman crashed her car through this building, destroying all of our lives, not just my family, everyone else that was in that building. My nephew and sister are still fighting for their lives. I had to be the one to tell my sister her babies were gone when they removed her ventilator yesterday. And she said, how am I supposed to live without my babies? Nobody should ever have to go to a birthday party thinking they're going to die. Medical history or not, every medication tells you not to drink. She knew she shouldn't have done it. If I had to see my deceased niece and nephew, I had to see their very, very last moment before that car was removed. I saw it, and my sister can't decide what she wants. And then babies, I can tell you right now, cannot have an open casket. It's a horrible, dramatic thing. I cannot close my eyes at night without seeing the babies and what they look like. That has to be traumatic.
Yeah.
Okay, he said he's done. And she's a known drunk. To her credit, she does have the community behind her. However, say something. I'm the brother of the father, Nicholas Phillips. He's going to speak. Um, this woman deliberately, without even a break, and she didn't break, destroyed my brother's life. This was his baby, his little girl. Used to go to his basketball games, and now that I look, the girl is not going to be able to go see her father because a woman claims to have high community ties to her community, wants to drive and hit the gas even further when she got to that parking lot and destroy multiple lives. My brother is in the hospital right now. Right now, his little boy comes through, and God tells his son that he lost his sister and brother. How is that right, or how is that even fair? He had extensive injuries, the older boy, brain damage, broken bones, and he's on a ventilator. and doesn't even know about that. So how is this even justified? Because the woman saying that she got some type of medical issue. As my sister said, you take medicine for years. You're a doctor. You could read the label. It says do not drink, and you can't sit here and tell me one drink that would do that. You can't. I'm a highly educated man. You can't tell me that, and there's no justifying what she did to my family. There's none. This will never, ever be right. There's nothing in this world that anybody can sit here and say, or she can say it was an accident. That was not an accident. I know an accident looked like that happened all the time on a freeway. If she was not drunk, as people claiming, her house is 3 houses away from what she did. Why didn't she just go home? Why did she do that stuff that she did to my brother's family? 3 houses. Why didn't you go home? Thank you. So you, as a defender, you should feel ashamed for even trying to stick up for only one drink. One drink, don't do that, sir. He doesn't like her lawyer, and it never will. Thank you, Your Honor. Okay, here's someone else, Rosemary. I drove there with my 3 children. We were there, whether you're having a seizure or not, that was intentional. You couldn't drive the way that those roads bend. And the way that you drive in there, there is no way that that woman was not conscious in turning the vehicle. She aimed it right there, right at the bar where probably her husband should have been sitting. I don't know what her intentions were, but I can tell you it was in purpose. And it was intentional. You can tell, we all know it. Okay. I don't think that that's correct. I mean, I do think I know. Yeah, we know it, but I'm not sure that's correct at a bond hearing. Okay, here's the next one. Josh. I'm a member of the boat club, and I've been a member for many years, and I'm familiar with Marshella. And during my 10 years being a member, I got to say, Marshella was formerly the Commodore of the boat club. So she was very familiar with the club and drinking in the club. And the mother of the children that were killed had just started working in the boat club 3 weeks before this incident. During my 10 years of being a member of the boat club, but most of the time, she's been highly intoxicated. And I've watched people trying to walk her out the door dozens and dozens of times. And you know, one of the things that aren't brought up here is the fact that she hit a vehicle down the road and a tree down the road. And I have a picture of that truck. She hit a truck a ways before she went into the boat building. And I believe that it wasn't intentional. I think this guy's right. But I do believe that it was a situation where she was trying to flee and run from what she had just done down the road. She shouldn't have been driving, and everybody knew that, right? Everybody, you're a member of the boat club. You know this lady shouldn't be driving. And I believe she was fleeing that. And there's a speed bump before you enter the parking lot to the boat club, as well as a runoff ditch that you got to pass over with your vehicle. We all drive 10 mile an hour through that area because of these, you know, and it's a narrow road. But I believe, what is that, Eve? But I believe that she was running from hitting the truck so you wouldn't get caught drunk driving. And in doing so, hit the speed bump as well as the little ditch that's 30 feet past and lost control of her vehicle. So I don't believe it's intentional, but I do believe that, and I know that she drinks a lot, and you know she should never get behind a wheel. And if you're under that much medicine, as her attorney states, then even one glass of wine could potentially, uh-oh. Uh-oh, I lost my place. Sorry. Yeah, she's not supposed to drive. She should never be behind the wheel. We've watched her take baby steps to get out of the place because she could barely walk. right alone, get behind a wheel. And, for such a frail lady to cause such devastation in her car, I think that she shouldn't be freed on bond because of this. I believe it's decades of her drunk driving that just caught up to her. Decades of her driving under the influence of whether it be pills or alcohol. And I would point towards alcohol from my experience of knowing her. Thank you, Your Honor. All right. I went over some of the issues that my decision in setting bond. High on that list is the fact that she's facing 2 life sentences, 2 15-year sentences, and 4 5-year sentences. Before I find reasonable bond, therefore I find reasonable bond to be $1.5 million with the following conditions. It will be reporting to pretrial services. Defendant is to appear for examination, arraignment, trial, sentence, and any time directed by the court. Abide any judgment issued by any court. Do not leave the state of Michigan without permission of the court. Do not commit any crime allowed on bond. Immediately notify the court in writing of any address change or telephone number. No use of alcohol or illegal controlled substances. Submit to substance use testing and monitoring, including a scram tether and GPS tether. Do not purchase or possess firearms or other dangerous weapons. Forfeit any passport and not operate a motor vehicle. What's a scram tether? Is that the one that can tell if you're on alcohol or drugs? I don't know.
I don't either.
Okay. The 1.5 million will be cash surety or 10% cash. Oh, the lawyer's still arguing. She has no history at all, Your Honor. Okay, whatever. 2 kids are still dead, right? So she was at this Verna's, which is the name of the bar that they did the search warrant on. She was at there, had 1 glass of wine, allegedly, and a bowl of chili between 11 and 12. Okay, so where was she between 12 and 3 when and if you looked at that, she's flying. I mean, I think that guy was right. That's just, I think that's a plausible explanation. If she was drunk, she hit that truck in a tree and she didn't want to get caught drunk driving, so she got the hell out of there. That's just my thoughts. Maybe she was on her way home from Verna's, which is her house is pretty close.
Could be,
there.
honey.
Yeah, maybe she just sped past her house and I don't know, but she definitely didn't brake. I'm saying she had a duty to everybody around there to not drink, not drive, and is a bar. I mean, it looks like the bar wasn't negligent at that point. So did she go home and drink more? I don't know what she was. There's some time in there where she could have. I know.
She probably had a bottle in her car or something and drinking it.
She could have. She was 0.8 something, so she was right at the limit, but the lawyer said that those results aren't accurate and that they're waiting for the blood test results. Well, the blood test results are quite a ways after, so they would be lower typically. He's probably hoping that it'll be under. I don't give a rat's ass. She killed 2 kids.
Yes, that's what I was thinking. She killed some kids and injured a lot of people.
And here's a thought. It doesn't matter about the epileptic seizure, allegedly, the alleged seizure, because she was drunk. So if I'm out driving drunk and a car hits me and it's not my fault, I still get a driving drunk ticket because I was driving drunk. Yeah. So she's responsible no matter what, as far as I can see.
That's the way I was looking at it, honey, too. I think, she should never get out of prison. She should spend the rest of her life in prison for what she done. I'm
Yeah,
sorry, she knew better, but those look what you've done to those families and those kids and stuff. I mean,
yeah, terrible, terrible. Oh, here I have a picture of the truck she hit. Okay, now here's a guy that posted. Oh, she was posting for the when she was the. This is 2017. She's when she was the Commodore of the boat club. She's hawking raffle tickets on YouTube or on Facebook. I thought that was interesting that she was the former Commodore, and then she worked for a bank or loan company, I think, but she'd retired a couple 3 years ago. Here's a guy posting Jordan Bush. She was not part of the party or coming to it. And that conflicts with I don't know if this is actually the one of the kids' dads, but because people said she was invited to the party and her husband was too. She was meeting her husband there. But this guy said he's the father of the birthday boy. He said, that being said, this woman knows my baby and has watched him grow up and would never intentionally hurt him or anyone. But her actions, her decisions that led to this are unforgivable, and she deserves what's coming to her.
that's the way I
Believe,
feel.
yeah, believe you me, they will throw the book at her. But as the father of the little boy's birthday it was, I can honestly say, in my own opinion, she would never do this on purpose. Once again, she deserves everything coming to her. Ah, yeah, there's a lot of functional drug addicts out there too. I worked with
Yeah, my
someone.
mother-in-law was
Your
a drunk.
mother-in-law?
Yeah, same thing Misha was saying. She was, that she was a drunk, but she was able to cope.
I worked with someone at UPS that I didn't know until she quit that job that she was an alcoholic. That just blows my mind. I never knew that. And here she's driving.
Yep, my
Awesome.
mother-in-law started drinking every day at 11 o'clock,
Oh my god. Okay, so
and she kept drinking till she went to bed. Yeah,
here's the boy. Um he has both his legs were broken, ribs were broken, and he suffered a fractured skull. His father remains by his side and is absolutely devastated by the loss. Um The mother had a collapsed lung, 6 broken ribs, severe cuts, bruising, and a knocked out tooth. She has been taken off the ventilator, but the older boy is still on a ventilator. And there were, see, 13 people injured. So take those 2 away. 9 were transported by ambulance. The 2 kids were transported by helicopters, the 2 that died. And, well, maybe, yeah. And then 4 people sought their own went by private party to the hospital. Don Marco, an attorney for Dodds, who is the mother of the children, has already filed a civil lawsuit against Chidester on Dodd's behalf. Said her oldest son, JP, remains in critical care after undergoing 7 hours of excruciating surgery following the crash. Matella Rodriguez, owner of Adelita's Mexican Cochina in Woodhaven, said Dodds Dodds is working at her restaurant. I'm sorry, not at the boat club. Dodds had started working at the restaurant 3 weeks ago. The restaurant is now donating 30% of its profits Tuesday and Thursday to her family. Um, that's so sad. Zane was an early childhood center. Lana was a second grade student. She's 8. Dad's oldest was still recovering, attend Simpson Middle School. Um,
well, this is a sad case all the way around. I mean, but
it's
she's got to
horrible.
pay for what. But she's got to pay for what she done. I mean, I'm sorry. I don't mean to sound so mean, but that's the way I feel. I feel like she needs to pay what she done for his
Oh,
family.
I absolutely believe that. Here, what does this say? Records from the Secretary of State's office indicate Chidester was arrested Saturday, and that law enforcement confiscated her driver's license and issued a temporary paper license. Michigan law says a driver's license must be confiscated if a driver is intoxicated or refuses to perform a substance test. The permit doesn't restrict driving privileges instantly. It remains in effect until the individual's case is resolved. That's kind of interesting. If you're intoxicated, they take your license, but they still let you drive.
No, I know of.
And it says in Michigan. That's where I am.
Yeah, I know that's where you are.
We had a guy here that had an accident with a ATV and was drunk, flipped it, killed his wife, was out on bond, got in another drunk driving accident, and was let out on bond, and got in another drunk driving accident, was out on bond. And like, how many times do you have to drive drunk before they do something to you?
It just depends on, yeah, I mean, it depends on the judge and the cops and everything. I mean, it just depends.
I mean, 3 drunk driving accidents all at once. Okay, there was Alina Phillips 8, Zane Phillips 4. They died at the scene. 9 other people were taken to hospitals. A couple of them critical. 31-year-old and 11-year-old boy. A makeshift memorial of stuffed animals and crucifixes emerged on Monday outside the boat club in Berlin Township. A
I
club
would never got
employee.
behind the wheel drinking.
What?
I said I would never got behind the wheel drinking.
I gotta say I used to, but back in the day, things were a little different than they are now. A club employee who did not want to be identified said Monday that the suspected motorist was a volunteer there. A statement from the boat club's board of directors Monday said they have no profound words for the unimaginable tragedy, only feelings. I see her car landed 25 feet inside the building. Here the tavern declined comment. I think they did issue a statement. Really? That's awesome. I think it should be. When I looked up things in Wisconsin, there was a person literally charged with the law that he violated was 7th to 9th drunk driving. 7 to 9? How do you get that high? I can't believe there's even a law for that. You shouldn't be driving if you have 7, 8, or 7, even 7.
They drive all the time like that. I mean, it's just they don't care. People just don't care. I mean, yeah.
Yeah, I think that, and there's a lot of law enforcement that are getting caught lately. This lady looks like she broke her arm. Oh, her attorney said she drives like a little old lady. She's had epileptic seizures in her legs that result in paralysis since November. Well, then she shouldn't be driving. I mean, if you have diabetes, I know somebody that had diabetes and she had her license taken away for 6 months or something because she got in an accident because she her sugar was low. I mean, anybody. Yeah.
Like I
Oh,
said, a lot of times it depends on the judge and stuff, what's going on in the situation. They don't, some judges don't crack down on stuff like they should.
yeah, that's for sure.
I mean,
You
yeah.
have to pay attention and vote on those judges.
And all states got their different laws too, you know. I mean, all states are not the same when it comes to the law, you know, so.
Yeah, I think that people don't like it when the Mothers Against Drunk Driving show up at a court hearing, but I think it's a good thing.
Yeah.
You got to show your presence and put pressure on the judge to hand down a stiff sentence. Okay, so here's the lawsuit. Mariah Dodds, JP, her son. by his next friend, Mariah Dodd's plaintiff, versus Vernus Tavern and Marshella Chidester. So they're suing the tavern too. Now comes plaintiff Mariah Dodds, who's the mother of the children, as next of friend for JP. I haven't heard of that before. By and through their attorney, Marco Law, for their complaint against defendants named herein and stay as follows. This is a negligence claim arising out of a car crash on April 20th, 2024 at the Swan Boat Club. And he gives the address, which we don't need. Plaintiff Mariah Dodd is a resident of Monroe County, Michigan. Defendant Vernus Tavern is a domestic profit corporation conducting business in Newport, Michigan, in the county of Monroe. Defendant Marshella Chidester resides in Monroe County, Michigan. The amount in controversy greatly exceeds this court's jurisdictional requirement. Factual allegations. On or about April 20th, 2024, defendant Chidester drove her vehicle through the wall of the Swan Boat Club and into a children's birthday party. Two of plaintiff Mariah Dodd's children were pronounced dead at the scene. Monroe County Sheriff's Office took Chidester into custody on suspicion of operating a vehicle while intoxicated, causing death. Plaintiff Dodds was seriously injured as a result of the crash. Plaintiff JP was seriously injured as a result of the crash. Upon information and belief, defendant Vernus Tavern overserved Chidester prior to the crash. Count one, negligence, gross negligence, willful and wanton misconduct. I agree there. I vote yes. Plaintiffs, by reference, incorporate the preceding paragraphs of their complaint as though fully set forth herein. On April 20th, defendant Chidester owed a duty to plaintiffs, so here we go, duty to plaintiff, to operate her vehicle with due care and caution and to obey the statutes of the state of Michigan, as well as the adopted ordinances in Berlin Township, then and there applicable to the operation of a motor vehicle, and to obey the common law of the state of Michigan applicable to said statutes. And that notwithstanding such duties, defendant Chidester did violate the same, wherein said negligence and or gross negligence did consist of, more particularly, as follows. To operate the motor vehicle on the roadway in a manner and at a rate of speed that would permit it to be stopped within a safe distance. And then it gives the Michigan compiled loss numbers, but I'm not going to read those. Excuse me. Not to operate the vehicle carelessly and heedlessly with willful and wanton disrespect for the safety and rights of others. To keep the automobile constantly under control. D, to attempt to stop the vehicle when defendant knew or should have known that failure to do so would naturally and probably result in injury to each plaintiff. E, to observe the highway in front of the defendant's vehicle when defendant knew or should have known that failure to observe plaintiff's oncoming vehicle would endanger the life or property of other persons using the roadway. F, not to operate a motor vehicle while intoxicated. G, in other ways not yet fully known. Plaintiffs reserve their right to amend this complaint as necessary and allowed. As a direct and proximate result of the negligence and or gross negligence and or willful and wanton misconduct of defendant, plaintiffs suffered serious and permanent injuries and damages. Plaintiffs realleges and incorporates by reference each and every allegation of loss of society and companionship consortium. So that's, loss of companionship of the two children. Defendants destroyed plaintiff's family relationship. Mariah Dodd lost her two children. JP lost his siblings. As a result of defendant's negligence and or conduct complained of, plaintiffs have a claim for loss of society and companionship and loss of consortium. Count 3, dram shop liability. That's the bar. Plaintiff hereby realleges and incorporates by reference each and every allegation contained above, blah, blah, blah. Upon information and belief, defendant Vernus Tavern Incorporated sold alcohol or liquor to defendant Chidester while she was visibly intoxicated. I'd have to see them prove that. She might have drank after she left. The actions of defendant Vernus Tavern through its employees and or agents were in violation of Michigan dram shop law. As a result of the acts and or omissions of the employees and or agents of defendant Vernus Tavern, defendant Chidester was able to continue drinking in the public establishment until the time she left and ultimately crashed her car into the Swan Boat Club. Defendant Vernus Tavern owed a duty to the members of the public, in particular to plaintiffs, to act in a reasonably prudent manner, including performing the following acts. And why can't I get to that page? Just a second. To stop and refrain from serving alcohol to Chidester, who was visibly intoxicated as required by MCL 436, to eject Chidester from premises and provide alternate transportation home for her. I'm trying to get to the next. I got a problem here. Uh-oh.
What's wrong?
Give me a second.
Okay.
I lost my place.
Oh no.
I'll get it back. Oh, I'm in OP photos. Here we go. I don't know why it can't. No, I got this phone that I really don't care for. Here we go. Okay. To eject Chidester from the premises and provide alternate transportation home for her. To train and supervise agents, employees, and bartenders to recognize and prevent a visibly intoxicated person from being sold alcoholic beverages and from becoming more intoxicated and then driving home. All other acts of negligence learned through the course of discovery. As a direct and proximate result of defendant Vernus Tavern negligence, gross negligence, carelessness, recklessness, wanton and or willful conduct, plaintiffs suffered severe injuries and will continue to suffer damages into the future. Count 4, negligent infliction of emotional distress. Bystander rule. Okay, bystander. And we've discussed bystanders and emotional distress in some of the cases. Plaintiffs hereby realleges and incorporates by reference each and every allegation contained above, blah, blah, blah. A party can establish a viable claim for negligent infliction of emotional distress for proving 4 elements. 1, that the injury threatened or inflicted on a third person was a serious one, of a nature to cause severe mental disturbances to the plaintiff. 2, that the shock must result in actual physical harm. 3, that the plaintiffs are a member of the third person's immediate family, i.e. parent, child, husband, or wife. And 4, that the plaintiff must actually be present at the time of the accident or injury or suffer shock fairly contemporaneous with accident or injury. This is kind of interesting. Okay, so we're almost done. The injury, okay, I already did that. The injury inflicted upon the third person was a serious one because it resulted in death. Plaintiffs have suffered severe mental and physical harm as a result of defendant's negligence. Plaintiffs were immediate family members, mother and brother of the deceased children. Plaintiffs actually witnessed the crash. Wherefore, plaintiffs hereby pray that this court awards plaintiff damages of whatever amount above $25,000 is fair, just, and based on the evidence presented at trial. Award plaintiffs interest on the judgment plus its cost and attorney's fees, and grant plaintiffs such other relief as is just. Respectfully submitted, Michael Jones of Marco Law. Hey, Bob. We're just wrapping it up. She was running around being careless. Absolutely. Oh, yes. No, Monroe, Michigan is what county? You'd think it'd be Monroe County, but I don't think it is. What did I just say it was? Your parents went from Ohio to Monroe, Bob, to elope? I thought it was Monroe City of Michigan is county seat of Monroe County. You are correct. Bob's right. Okay, so I thought that was kind of interesting with the epilepsy, for crying out loud. Yes. Yes, yes, yes. She knew she couldn't drive. She knew she had epileptic seizures that paralyzed her legs.
Yes.
Why would her doctor release her restrictions like 3 weeks before this? That didn't last long. She knew she shouldn't be drinking when she's taking her medication. She knew she
Yep.
shouldn't be driving while drinking. As for Verna's Tavern, I'm not sure. I'd have to know if they only served her one glass of wine. However, you got that guy that knows her that said she's drunk in there every day, and they have to help her walk out to her car. So I'm pretty sure that they'll be able to round up more witnesses that were in the tavern. I don't know.
Yeah, like I said, this is what she done. She needs to pay for it, and she needs to be put in prison for the rest of her life.
How
I mean,
terrible. Yeah. And for the mom and the brother to have to see that, and all the other kids that were there. How
yeah,
traumatized they'll be. Yeah, this is horrible. It's a horrible tragedy. I see there's several other boat clubs there that are giving their support to this one in the community. Yeah,
don't get me wrong. My heart goes out for her, to her.
oh, mine doesn't.
But but she knew better than what she was doing. She knew she shouldn't be drinking and driving. She knew she shouldn't be doing all that. So
Yeah, I don't feel sorry for her a bit. She knew. Yes. I don't think she was negligent. I think she was deliberate in her driving. Really? Well, Bob, how cute. My parents didn't elope. They had a big wedding. Well, not huge because I mean my town only had like 200 people, but still. It's got one stoplight and actually less buildings than it had back in 1880. It's shrinking. Okay, thanks everybody for being here. Thanks for playing. Yes, she does need to take her punishment. She didn't look like she had any reaction. I wonder if they've got her sedated or something. Just looked blah. She was limping into court though, and she's got a broken arm there, but so good. Okay, good night, everybody. We'll see you Thursday. Have a good
okay, honey. I
week.
enjoy being up here with you and stuff.
Thank you. I appreciate you coming up here, Eve. Night, Rakes, Bob.
I love you, girl.
Night, Eve.
Good night. Goodbye, Cat.
We'll talk to you later. Bye.
Bye.